Welcome to Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. This week, we talked to a couple of lawyers who specialize in making other lawyers angry. In the second half of our show, we'll be joined by Ted Frank, Director of the Center for Class Action Fairness at the Competitive Enterprise Institute, to talk about his quest to stop class action lawyers from ripping off the clients they're supposed to be representing. Up first, we welcome Clark Neily, Director of the Center for Judicial Engagement and Senior Attorney at the Institute for Justice, who'll help us look at the power of judges and the politics of their selection. Clark, welcome to the show.
Thank you. Nice to be here.
Clark, we live in an age where many legislatures, both at the national and state level, are mired in partisan gridlock. And in many cases, that leaves it to judges to mold the law. How has the role of the judiciary changed from that imagined by our founders?
Well, I might check that premise a little bit. What I would say is that legislatures, both at the federal and the state level, involve themselves in far more things than the founders of our country ever would have thought. And so then the question becomes, if you've got the other two branches of government involving themselves in our lives in ways that the framers would never have anticipated.
For example?
Oh, well, I mean, look, everything from the federal government running public education, or at least being significantly involved in public
education. People have gotten
education.
used to that.
Okay, but it's still not a constitutionally legitimate thing for the federal government to be doing.
Okay.
Involving themselves in the very details of who's married to whom and what kind of tax benefits we get with that. I mean, there was a civil ceremony back in the day. So I personally think, and this works best, I think, at the federal level. There's no doubt about it that Congress is far more involved in our lives than it was ever supposed to be. I'll give you one example. There was a famous case from I think it was 43, U.S. Supreme Court, and a farmer named Roscoe Filburn in Ohio grew wheat on his own farm for his own consumption. And somewhere in the bowels of the federal bureaucracy was an agency where they knew exactly how much wheat each individual farmer in America should grow, and Roscoe Filburn grew more than the federal government told him he could grow. But that's right, you know. So there was an allotment, and he grew more wheat than he was allowed to. And when they came and told him they were going to fine him for growing too much wheat for his own consumption, he said, on what constitutional basis? What power do you have to reach my purely local production?
Yeah, he wasn't in interstate commerce. He wasn't selling it across state lines.
That's right.
And this went to the Supreme Court?
Yes, it did. It's called Wickard v. Filburn. And the Supreme Court announced one of the most destructive constitutional doctrines in the history of this country, and it's called the aggregation principle. And what they said was, fine, your conduct might not affect interstate markets by itself. But if every farmer in America did what you're doing and failed to purchase wheat on the interstate market because they produced it at home for their own consumption, that would have an effect on interstate markets, and that becomes the basis for federal power. And guess what? Once you do that, there is no human activity that escapes the ambit of federal power. You're done.
So was this judges making law?
Yeah, of course it was. And well, let's be clear. First, it was an activist Congress violating the Constitution by regulating conduct that the Constitution does not empower it to regulate, and then it was a Supreme Court rationalizing that power.
After the fact.
After the fact, rationalizing that power when it was blatantly unconstitutional. And by the way, that's basically what we've had since then, is a go-along, get-along Supreme Court that bends over backwards to say yes to government when it violates the Constitution.
Don't they call that deferring to the will of the people?
Yes. Well, I would strongly disagree with that. The most important law in this country, written by the people, is the Constitution. And the Constitution does not give the federal government the power to dictate to farmers how much wheat they can grow. So that's the voice of the people that the courts should be respecting. Instead, what they're respecting when they defer to what some people would call the voice of the people are transitory political majorities. And you and I both know that it's not even always political majorities, right? It's often special interests that have an interest, for example, in promoting the sugar subsidy, another blatantly unconstitutional policy that I'm sure a majority of people in this country don't support, but it's supported by factions and special interests, and the Supreme Court bends over backwards to say yes.
Clark, you sound like a passionate constitutional lawyer. That puts you really in the minority in the world today. It sounds like an uphill struggle. And one of the things I wanted to chat with you about, not only worried about what I think they call Title II law, which is constitutional law, we seem to have this parallel branch of the judiciary now called the administrative law courts. Is that anywhere in the Constitution?
I mean, look, you could make an argument. To be clear, what we're talking about here is when Congress passes one of these really broad laws like the Clean Air or Clean Water Act and says, just make the environment.
Go figure it out.
Yeah,
right.
Go figure it out. The people who figure it out are at the agency. So you've got Article 1, that's the legislature writing a very broad law saying, something aspirational like make the environment better.
Yep.
Then you have to have that law implemented. And that's the duty of the executive branch, and that's the federal agencies like the EPA.
And they write all the regs.
Well, that's right. They have the power, and I think this is pretty uncontroversial, to write what are called regulations that are simply detailed explanations of how the law will be implemented. The problem is that over time, Congress has gotten less and less specific in its lawmaking, leaving more and more up to the agencies in terms of what the policy will be. And at some point, you cross the line from executing the laws, which is constitutionally legitimate, to really writing the laws, to making policy at the agency level, and that is blatantly unconstitutional.
And this gets resolved by administrative law judges?
Well, that's right. So what happens is you have this agency that is engaged in the unconstitutional policy-making role, and then if it thinks you have violated the policy that it unconstitutionally promulgated, guess who decides whether you are... So basically, they make the policy, then they investigate possible violations of that policy, and if they want to fine you, or some of these rules or regulations or even have criminal sanctions, you go before an administrative law judge that works for the same agency that promulgated the policy, that brought charges against you, and then you get judged by that same agency. One of the most dangerous things that all political scientists from the Western Enlightenment tradition have agreed on is that when you combine in the hands of one entity the power to make policy, to execute policy, and to adjudicate violations, that is the end of limited government.
I think this is what we learned in 5th grade about separation of powers.
We were supposed to have learned it in 5th grade, that's
but
right.
But it's gone now. So here we are in a world where judges have a lot of power. Either the ones who are constitutionally supposed to have the power going up to the Supreme Court, or now we have regulatory agency judges of their own making. But choosing those judges gets very important. And we hear about this in the news when these become contentious. I certainly remember, 30 years ago now, a very famous Supreme Court nomination fight for Robert Bork, who's since passed away. Remind our younger listeners what that was all about, because it was a watershed moment.
Robert Bork was an extraordinarily well-qualified Supreme Court nominee who was nominated by President Reagan to fill the seat vacated by Justice Lewis Powell in 1987. And when I say qualified, I mean really well qualified. He had been a Yale law professor. He had been Solicitor General of the United States, the number 2 lawyer for the Department of Justice, and he had been a judge on the D.C. Circuit Court of Appeals, which is traditionally a kind of a feeder court to the U.S. Supreme Court.
So this wasn't just the president's personal lawyer that he tried to slip in the middle of the night?
Not remotely. Now, Judge Bork was a very controversial
I'd remember that.
Because of his judicial philosophy, and his judicial philosophy was basically one of strict kind of textualism, or he's sort of an originalist textualism. Yep. The Constitution means what it says, and restraint. Basically, the idea that the judges should be very, very reluctant to interfere in the political process, and that his view, and this is one of the most famous things he's ever said, is that in America, majorities are entitled to rule if they wish in vast areas simply because they are majorities. He had a very, very constrained view of what the Constitution prohibits, and basically anything not explicitly prohibited by the Constitution is permitted. And that really was what was mainly controversial about him as a nominee. And by the way, I would add, as a libertarian, I strongly disagree with that interpretation of the Constitution. I think the Constitution is a primarily liberty-protecting document and not a primarily government-empowering document. But Bork saw it the other way around.
But in any event, he raised the ire of some powerful people, and an awful fight took place.
He did, particularly Teddy Kennedy, who was one of the most influential senators on the Senate Judiciary Committee. And some people may remember that Ted Kennedy did a very ugly thing with Bork, which was that he said that in a world in which Judge Bork is on the Supreme Court is a world in which women will no longer be able to achieve or to obtain legal abortions, and it'll be a place where women have to go into back alleys and have abortions with coat hangers. A very, very unseemly and vivid image. And those were the long knives that came out for Judge Bork when he was nominated to the Supreme Court.
And eventually his nomination was defeated.
That's right. Judge Bork was not only rejected by the Senate Judiciary Committee in a 9-5 vote, but he insisted on getting a full vote before the Senate itself, and the Senate rejected him 58-42, and so his nomination went down in flames.
And this set the stage pretty much for every Supreme Court nomination since.
I think that's fair to say.
I think the word Bork became a verb at that point in terms of how you defeat a nomination. And the next one I remember vividly was a Clarence Thomas nomination, which turned into something of a circus. Remind us about that.
So Clarence Thomas was, again, a very highly qualified, I think a very highly qualified nominee to the Supreme Court. He'd held a senior executive position in the EEOC. He had been on the D.C. Circuit Court of Appeals. But he was very controversial because he was a conservative black nominee.
Which seems to frighten a lot of people.
Well, I think it frightened and or offended a lot of people because I think for some people there is a conception that people of certain demographics should have certain political views, and Clarence Thomas bucked that trend.
Rather than talk about his qualifications as a judge, some strange charges were leveled.
Yes, unfortunately, the whole confirmation process was, I think, really kind of sidetracked into this controversy about whether Judge Thomas, who was then a judge, Clarence Thomas, had or had not made some sexually explicit and perhaps harassing remarks to a subordinate of his named Anita Hill, who worked for him when he was at the EEOC.
And this was heavily sensationalized by the media.
It was. The images were quite graphic, and Clarence Thomas himself later referred to the whole process as a, quote, high-tech lynching. It was very ugly what happened, and really it was a very, very polarizing process. And basically, we don't know to this day what, if anything, actually transpired between Clarence Thomas.
It was a classic he said, she said.
It really was. It really was. Look, no one else was there either, so we don't know what was said, but there seems to be some reason to believe that this looked like and felt like to many people a political hit.
In any event, it certainly changed the business model of Supreme Court nominations, particularly with the media involvement. They became platforms for reaching the base, even independent of the outcome, because Clarence Thomas was eventually accepted. He
was confirmed, and one thing that bears mentioning is virtually everybody now concedes that he is an absolutely brilliant Supreme Court justice. There was this early caricature of him that he would just be kind of a step and fetch it for Justice Scalia. And in fact, the opposite has turned out to be the case. Justice Scalia, if anything, is more influenced by Clarence Thomas than the other way around. Clarence Thomas is an absolutely brilliant Supreme Court justice, and whether you agree or disagree with his ideology, it is to everybody's benefit, I think, to have really smart, principled people on the Supreme Court. And we should add one thing. Nobody knows what actually happened between him and Anita Hill. But if we judge Clarence Thomas purely on his performance as a Supreme Court justice, it has been exemplary.
Do you think he was permanently bruised by the process, and that's why he never asked questions?
Those who know him would say that, yes, he was permanently bruised by the process, and that the fact that he doesn't ask questions has something to do with that process. But he's been quoted as saying he doesn't really think that the question and answer dynamic adds much to the deliberations of the justices and really just becomes a kind of a stage for people, including other justices, to pontificate, and really isn't very helpful.
Talk a little bit about the kind of nominees we've had since then. Have presidents been playing it safe?
I think by and large they have. Unfortunately, one of the sort of shared characteristics that most Supreme Court nominees seem to have today is that they've virtually never taken up for any significantly controversial cause.
Right.
And they have very little in the way of a paper trail. Maybe some memos they've written when they served in, one government office or another. And certainly if they have been a judge before they were put on the Supreme Court, as Roberts and Alito and Sotomayor were, they've written their opinions. But basically now you're looking at people who are, in large measure, blank slates.
An enigma.
Yeah, and I think that's a terrible thing. Look, if you've been interested in constitutional law for 25 or 30 years and you haven't found anything that you find objectionable or worth getting on board with, that concerns me.
And so here we are heading into an election cycle, the outcome of which will decide who might get to name as many as 4 new Supreme Court justices. We're at a strange equipoise right now between the classic liberal and conservative branches, and there have been a number of controversial opinions that have been handed down. Handicap what we're likely to see ahead.
Well, of course, it depends whether we get a Democratic or a
play
Republican
both sides
president.
for us.
Okay, so if we get a Democratic president, we know exactly what will happen, and that is that the Democratic president will try to find a nominee who is as progressive as possible but still confirmable. And we've seen that play out time and time again. What's really interesting is on the Republican side. If we get a Republican president, one of 2 things will happen. Again, if it's a Democratic president, one thing will happen. They go for the
predictable.
Very predictable. They go for the most progressive nominee that can get confirmed. On the Republican side, there is a schism among limited government conservatives about what to look for in a justice. The old view is look for somebody like what Chief Justice Roberts was, somebody who will pledge to be restrained, deferential to the other branches, and modest. That's the judicial
This is a
restraint.
go along, get along.
Well, that's how I would characterize it. This is judicial restraint very much in the Borkian mold that, look, very little of what the other branches do is any business of the court. The Constitution permits the government to do virtually anything. That is one way of looking at it. The other side of it, and this is relatively new, but it's attracting a lot of attention, and I think it could be a very significant dynamic for the next Republican president, is what we call judicial engagement. And that is the idea that judges should not be hesitant to strike down what the government does, and instead, judges should be as active in striking down or declaring unconstitutional government action as the other branches are in acting unconstitutionally.
That's pretty aggressive.
Well, what would you rather? I mean, look, if you've got a government that is consistently passing unconstitutional laws, and I believe that's the case, and you have a judiciary that does not consistently declare laws to be unconstitutional, it's a kind of a constitutional arms race. And what's been happening for the last 80 years is that Congress has been passing unconstitutional laws, and they've been getting rubber stamped.
So put your personal values down for a moment.
Okay.
I know this is hard. And try to do a political analysis.
Okay.
If there's a Republican president and the emergent branch that really wants to see judicial engagement and more laws being struck down prevails, can such a candidate get through the nomination process?
Yes, maybe.
What would the strategy be?
Take a look at what are two of the most outrageous offensive decisions to conservatives in the last 15 years. One of them is probably familiar to your readers. Well, they both are. Kelo versus City of New London. This was the eminent domain case where 5-4 vote of the Supreme Court said that you can use eminent domain simply to bulldoze a working class neighborhood and replace it with Yuppieville.
That's been such a disaster in the aftermath.
It has, but and it was a blatant misreading of the Constitution. The Constitution only allows private property to be taken for a public use, not for just, building nicer neighborhoods.
Give it to my friends and make taxes go up.
Exactly right.
Yeah.
Exactly right. So that decision, the Kelo decision, prompted the biggest and most intense backlash in modern history to any Supreme Court decision.
At the state level, too, they passed a lot of laws trying to mitigate it.
They did, because the Supreme Court, instead of doing its duty and enforcing the U.S. Constitution, tried to kick the can over to state judges and state constitutions and say, well, we're not going to protect property rights, but if states want to under their own state constitutions, they can certainly do that.
Isn't that interesting? And as I recall the story, they tore those houses down to give it to a pharmaceutical company, and there's an empty lot there now.
That's exactly right. This project was from start to finish about basically providing for Pfizer's desires to have a nice...
That's right, it was Pfizer. Headquarters, yeah.
Yep. And you're exactly right. So we went from a working class but perfectly decent and nice neighborhood to a giant 90-acre brownfield. And it only cost $88 million in taxpayer money.
So it enraged a lot of people. Subsequent events bore out the fact that this was a bad decision. And your point was what?
Well, it's not just a bad decision. It's a particular kind of bad decision. It's one of these judicial rubber stamps where they said, we need to be deferential to the other branches and to the policymakers who think it's a good idea to bulldoze neighborhoods and rebuild them as Yuppieville.
Okay.
So that's point one. The other decision that conservatives are very upset about, justifiably, is the upholding of Obamacare, where Chief Justice Roberts literally rewrote
the first time or the second time?
Both times. Both times, Chief Justice Roberts supplied the deciding vote. Well, first time was 5-4, the second time was 6-3. But both times, Chief Justice Roberts rewrote provisions of federal law to get the square peg of Obamacare into the round hole of the U.S. Constitution. And that's what it took, by the way, to uphold that law. And so, to go back to what we talked about a moment ago, that is the dichotomy. When you have a Republican president, they can either choose somebody who's going to defer to the other branches, which is what Judge Roberts emphasized in his confirmation hearing, or you can pick a Supreme Court nominee who is going to enforce the Constitution as written. And by the way, the Constitution prevents a lot more government action than the current Supreme Court says it does.
But then again, my question was, how does such a person get through the nomination and acceptance process?
I think it's by saying to your base, for example, if you are a Republican president, presumably you have a conservative base, and what you say to your base is, I'm not going to be around in 4 or 8 years, but my nominees will be. And the next time we get a president that tries to pass a federal law taking over 1/6 of the economy, a law, by the way, that was rammed through on party lines, and is so ineptly written that it has to be rewritten by the Supreme Court to pass muster, do you want a Supreme Court justice who's going to rubber stamp that law or see it for what it is and strike it down?
So let me see if I understand this. You're saying bring in a Supreme Court nominee who will restrain my power, even though I'm in power now, and you might not like that, conservatives, but it'll be great when I'm not here anymore.
Yeah, and I don't know if I would put it in
That's a tough sell.
It is, but only if you agree that that's a somewhat cynical way to put it. What we might say instead is, We have the most prosperous nation the world has ever known.
We had.
I think we still do. We used to have the freest nation in the world, and we're slipping on that a little bit. But we have the best Constitution, in my opinion, ever written. And if you want to see that Constitution enforced the way it was intended, which is a Charter of Liberty, then what you want is a fully engaged judiciary. We don't have that right now. I think a talented president could make a case for nominating engaged Supreme Court justices instead of a bunch of yes men and yes women, because that's what we've been getting, and it's time for a change.
Is it possible to have all this happen without upsetting the status quo on the hot-button issue of all time, which is abortion?
Oh, absolutely. Because abortion is unlike any other constitutional issue in the sense that it very plausibly involves the interests of two independent human beings. It is the only constitutional right in which you have the interests of two human beings at stake, and that makes abortion unlike every other constitutional right that comes before the Supreme Court. Roe v. Wade is literally sui generis. That means by itself, unique. And so you can absolutely get an engaged judge who will step up to government when it violates the Constitution and say no to government in a way that the current Supreme Court doesn't. That doesn't enable you to predict in any way what that judge's position would be on abortion.
But from a realpolitik perspective, could that kind of deal get cut?
Well, it depends on what you mean by that kind of deal.
I'm going to enforce the Constitution. I'm going to leave abortion as the status quo, which if you promise that to the left, they might take some interest in this.
Oh, I see what you're saying. Well, yeah, I mean, of course. But, that starts to get into the question of how much is it ethical or legitimate for a Supreme Court nominee, or indeed any judicial nominee, to commit themselves to.
It's the litmus test.
It is the litmus test, and John Roberts provided the perfect blueprint for how to avoid committing yourself too strongly to any given issue. He didn't commit himself to anything other than the proposition that he would defer to the other branches. That has certainly been borne out. So I actually don't think that hot-button issues like abortion, or for that matter, guns, or affirmative action, or any other hot-button issue, will be or should be dispositive of future Supreme Court nominations. The single most important issue going forward is a judge's understanding of the Constitution and what it permits and what it doesn't permit, and their willingness to say no when the government violates the Constitution.
So, Clark, we're very familiar with IJ's role in protecting the little man out in workplace regulations and in forfeiture cases. This is kind of a different playing field. Tell us a little bit more about the Center for Judicial Engagement and what else IJ does.
So we created the Center for Judicial Engagement 4 years ago, and it arose out of this realization that we were seeing the same thing over and over again in many of our cases, which is a refusal on the part of so many judges to really meaningfully engage with the text of the Constitution, and instead just sort of rubber stamping whatever the government does. So we created a kind of a think tank within IJ to articulate that problem and to advocate for a different approach. And I would say this, look, the most important thing that we can hope for in a Supreme Court nominee is not that they adhere to a particular philosophy or ideology, but that it is someone who cares deeply about the Constitution and who has spent the time to study it and to understand it and to act on the basis of principle, whatever that principle is. That is the path going forward. And if we get that, look, everybody will always be unhappy with at least some nominees, but if we have really brilliant, principled people who get nominated to the Supreme Court, that's the best thing we can hope for in this country.
Well, Clark, thanks for being on the show today, and thanks for telling us a little bit more about a piece of IJ I wasn't familiar with.
I appreciate the opportunity. Thank you.
That was Clark Neily from the Institute for Justice, here on Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. You can check out Real Clear Radio on Facebook or follow us on Twitter at Real Clear Frezza. And stop by RealClearMarkets.com, my go-to place for diverse views on political economics. Real Clear Radio Hour is a not-for-profit, donor-supported program. Please stop by RealClearRadio.org and hit the donate button or contact us to become a corporate supporter. Ahead, Ted Frank at the Center for Class Action Fairness examines the fee-feeding frenzy that drives class action lawyers. Stay tuned.